is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everyone to this Tuesday, February 15th, 2011 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. We've been running some reruns here the past couple nights for the shows, and I hope some people have been listening to them so they could learn about some of the back foundational for NTT. So I hope you have some questions on what was gone over. So let's open it up for Q&A and see whether or not we have anybody that has any questions. They've been listening on what the material was on the last couple nights.
Q&A session started.
So press star 6 followed by 1 to raise your hand, get in a queue line, and ask questions. Star 6 followed by 1. Anybody?
Hey, Christian, how are you?
Hey, Darren, how are you?
Good. I have kind of like two questions. The first one, Eric and I were kind of like having a little discussion on, I wouldn't call it an argument, but is it necessary to first, like in an indenture, put instructions in and then orders? Because isn't an instruction a little bit different than an order? You know, it's like you can instruct someone to do something, but then you got to order them.
Yeah, well, I think this indenture is not a true, like an order, so to speak, that you're going to have to put in instructions in an order. Although you could do it that way, but, you know, it's more or less just the grantor setting down his intent and purpose, what he wants, in either in paper or in oral.
Yeah, well, it's kind of like the way that I draw this is just like if you're like in a court action and you want the defendant to do something, you're going to make a motion, you're going to instruct the court to compel them to do something, and then the court's going to order them to do something. So I'm just saying, just in the indenture, which is almost redundant as the orders, except the one's going to say instruct, the first part's going to say instruct.
Yeah, I don't think you really need it in an indenture because this is more or less agreement between the grantor and the trustee that he is going to do a certain duty, and he doesn't have to be ordered, only when he breaches the agreement. That's when you have to go into court and have the court order him to performance.
So you're saying then we just instruct? Is that what we do, or do we order?
Yeah, well, this instruction is what I want you to do, and you agree to it. So this is what how we're going to operate. This is what your duty is. This is what your obligation is to me. And then when they don't do that, they're in breach of that, and then that's where the enforcement comes in under the Court of Equity.
Right, but so are you saying that we don't include that in our original indenture, instruction, and special orders?
No, I don't think it says any place in Gilbert's where you got to have, say, an order for any kind of thing. It's just an instruction that the trustee agrees to. That's what he's going to do.
Oh, maybe I'm saying it incorrectly, and maybe you're thinking as a order as far as a court, but me as the grantor, I'm going to command and order him for a performance or a duty.
Yeah, because we don't use precatory language. We use command, order, decree.
Okay, so here's my point. Let's just say, for an example, just to give you an example, say that you are hereby instructed as a trustee to return timely any rents, fees, uses, proceeds, property, etc., etc. And then...
Well, there's where the precatory language comes in, which Gilbert plainly talks about and says, hey, when you're talking about trust, you don't talk about precatory language. You either command, order, decree, declare.
Okay, so don't use the word instruct then.
No, I don't think so. And Lump's going to come in there and say back, which could be your order part, because actually that's what you're really doing, I guess.
Okay. The only reason why, and this was something that I went over with some former TAs, and that was it, but of course they're no longer with us. But okay, so Eric was right. I give Eric the credit that just stick with just the orders. Don't worry about instructions. Just stay with orders. You are hereby ordered and commanded as a trustee to return timely any and all rent, fees, uses, etc., etc. In that example.
Yeah, the actual instruction would be the command.
Oh, you're saying they're synonymous?
There's only one thing in trust: the instruction,
order.
Command.
Okay. The instruction and command, that's two separate things. Instruction and command. So you're saying
they're the
same thing.
You could make it two separate things if you wanted, but that leads to kind of...
redundancy?
Yeah, because especially if you got something long...
Okay, but that's okay. I just, I question it just to be sure that the form is proper.
Back under the indenture section under Gilbert's.
Okay. Yeah, I'll do that. Yeah, that was just something that I just had a question about. And let me see. I also wanted to ask you. I got to pull it up on computers. That's a little slow tonight. Is on our UCCs. Now the thing is, of course, in let's say a case. Actually, there was actually another question. Because I am serving an indenture in my UCCs to a state officer, okay? But I have recently found out that this officer is no longer there because they basically had to change during the election. Do I have to file new UCCs, or how could that be remedied since everything's already been filled out in the UCCs?
Well, did the office break your trust, or did the individual person? Because if it was the office, then whoever came into the office then is going to take on the new responsibility for defending that, or being responsible for it.
Well, you see, that's what I did in the indenture, where I had, just hypothetically, I had Lisa Doe, formerly trustee. Now it's Larry Doe, that's the current trustee. I put that in the indenture. In other words, it's still showing the former, the way it's set up on the UCCs, but now we have a new changing of the guard.
Yeah, so whoever was the successor then inherits responsibility and liability then. So if there was a changing of guard, then that new guy, he's the guy you're still going after, right?
Yeah, because really it was technically, it was the you might say it was the agency, but they still have an executive director of the agency that basically oversees everything.
Right.
And that would be so really, and you got to name a living person when you're talking trust, so you got to go after the top dog.
Right, unless you're going under statutory.
No statutory, total trust. Okay. Now, take for example, if we use where in our, let's say even just our first UCC one, where of course we're showing the alternative designation, grantor, grantee, nomenclature change, non-UCC filing, and then we basically saying that this is a public notice by the grantor as holder and owner of all right, title, and interest with non-negotiable instrument claim number, which of course we use a specific number, and I always end it -001. And I also state on there that it says from 001 to 999 inclusive, with all attachments, proceeds thereof, of claims of all general deposits belonging to me, are being held in private. Now, of course, that 001 would be just for, say, this particular case. But that lays claim, from the 001 to the 999, that lays claim to numerous trusts out there. But just for this example, we're talking the 001 along with the other numbers that say on the registered mail. Does that sound right, or did I not say that wrong in confusion?
No, yeah, you're claiming all the numbers for whatever purpose you want. This
Right,
case,
but
that case, any other case. But you're claiming all the numbers on one UCC.
Okay, so let's just say for an example, yeah, but the thing is, that's under number 4 of the financing statement. But if we start, let's say, if we have another action in equity or suit in equity that we want to partake down the road, we still got to file new UCCs with different trustees' names on it, correct?
Utilizing those other numbers, yeah.
Correct. And then, so let's say my next one will be John Doe, ABC Bank. Then I would have that. I could still use that same registered mail number because it's retired, but it would be 002. So that's kind of like my second trust.
That's right, yeah. Mm-hmm.
Okay. See, so in other words, I got that all set up, especially where it's 001 to 999. That means I can have up to 999 trusts that I could claim, and all I have to do is just make the public record of something being held in private via non-UCC filing. I just have to go in and make new UCCs with the correct trustees on them.
How many numbers are those?
Well, what I have, I hear from 001 to 999 inclusive.
Okay, so that's 999 numbers, right? So that's 999 different titles.
Correct, right. And you got to consider, in our lifetime, we've probably done that. Easy.
Yeah, more than that.
Maybe more. Yeah, maybe more. But let's say, for an example, if I'm going to use a non-negotiable number, let's say my name abbreviated, DJM, and then let's say 1, 2, 3, 4, 5, 6, RR, and then whatever, let's say 1, 2, 3 dash 001. Now, that's just for one action, and I could keep that same number. The only thing that would change would be it'd go to 002 on the next one that I want to create. It's really, we're only changing the end part because we could keep that same number because it's retired.
Yeah, the same beginning number, but it's really unique because it's got the other numbers behind it.
Right. Okay. Hey, that answers it. So all we have to do is just create new UCCs with the new trustees in our next possible suit in equity. Correct?
Yeah, just use new number and...
new UCC, right?
Yeah, just pick a new number and just like a checkbook, go to the next number.
Right. Because then we would have to put in a different debtor's name, which actually then gets changed under the finance to the finance statement under the alternative designation. That all gets changed, because now we have different entitlements.
Yeah, since you've already claimed them, you don't have to claim it again, so that you don't have to claim that part. So, but then just sign a new number.
Right, but we still have to do new UCCs, right?
Yeah.
Okay. That's
for a different purpose.
Correct. Right. Okay, that makes it very, very simple. Still haven't found the 1958 equity rules yet. I'm still looking for them. I can't find them. Hopefully we'll be able to find those. I'd like to see what they say. I'm more curious than anything else. I want to see. I'm sure there's not going to be a large variance from the 1912, but I'm sure there is some alteration of it.
Did you find the 1935 change? I think it was 35 change.
No, I'm only on just what actually you gave was a 1912. I'm still looking for it. I have a bunch of feelers out. I even wrote Florida's the legislative body up there, and they had no clue what I was talking about. They had no idea what I was talking about. It was like I spoke a different language to them. It was funny. Okay, so that's fine on that. And then this way, on the indenture, we'll just put orders in, take out the hereby instruct. We'll just go straight to the hereby command and order, and then that should remedy everything. Okay, that makes it much easier. I appreciate that very much. That was really my only question I have at the current time.
Yeah, command, order, and decree. Declare. Just what Gilbert.
Command.
Non-precatory language.
Decree. I might throw in decree on top of it. Use all three terms: hereby command, order, and decree. I'll have to look in. Okay, that was my only question. Those were my only questions I had, Christian. I appreciate it.
Okay, there's nobody on the board, so *6 followed by 1. Anybody? Ask a question, raise your hand. *6 followed by 1. *6 followed by 1. Anybody? Guess those old shows over there, everybody knows it all, no questions on, everybody's got it. They can put their indentures together, and we can go on doing a bill of equity then, huh? Any questions, anybody? No questions? I think we'll do another repeat then. Anybody? Hello, John, you're on.
Hey, Christian. How you doing?
Good.
I was wondering, when you're doing the indentures, are you really putting a lot of the trust terminology in these indentures to make it sound like it's a private trust that you're forming with these guys, or are you actually, bringing them into the trust unknowingly? As you say over and over, no one really needs to know that the trust is being formed. But in this situation, are we trying to inform them that we're forming their trust?
Depends on the purpose I'm trying to accomplish. I might want to do it secretively, and maybe I might not. So it just depends.
Right, because I'm kind of looking at that, putting the indenture together right now for a case. It's just a credit card thing, and they're trying to do a enforcement of the order from the judge on the law side. But I'm thinking,
the time I'm going to have to make known that there is a trust is the time I'm going to try to enforce it. So that's when it's going to have to be known.
Right, and this guy's out of town attorney, trying to get some information, duces tecum, to enforce the order. But yet, if I'm forming a trust now and putting my evidence together of the trust, I want to claim the case, the whole case with everything attached thereto, and make the attorney the trustee. But I don't really want him to know that he's a trustee at this point, I don't think.
Well, you don't have to let him know. So it's just, you're holding this in confidence, and I want it back sometime in the future along with my interest.
Right. So yeah, I'm just hearing everybody talking about, how they're putting these things together, and it seems to me like maybe we don't need to let these people know that a trust is being formed necessarily. So.
Oh, you don't have to.
That's all.
You got the elements there to prove the trust exists through the trust test, and that's the only thing you've got to be considered with.
Yeah, exactly. That's what I've put together so far, and I've got a little while to deal with these guys. So I figure I can put it together, and once they try to get me in contempt, I'm going to have to enforce it. But I don't want to give them too much information at this point. So that's all I wanted to talk about. But I didn't get to listen to the past couple of shows, so I don't know exactly what those back recordings were, but I've listened to a lot of them. So I'm up on just how to put the indenture together. I just don't want to be too specific in informing them because they don't trust to be informed at this point.
Oh, yeah, you can do it that way. Don't have to tell them. They don't have to know.
All right. Well, thanks a lot. I'll let somebody else get on. Hopefully there's some more questions.
All right, thanks. Well, you're...
How you doing?
Good, Don. How are you?
Can you hear us okay?
My ears okay?
Can you hear us okay?
Oh, yes.
I had it unmuted. I wasn't sure that you were getting through.
Yes, we can hear you fine.
Well, we just thought we might give you a update on our situation with the bankruptcy. We had another hearing today as the case was transferred over to Chapter 7, so we're starting over. So we had a meeting of the creditors today, and the only creditor that was there was the attorney for the Arkansas Department of Finance.
And what?
And he brought up during the conversation he wanted me to give him the legal authority for my requesting the hazard bond. And I told him, well, I didn't know what you meant by legal authority. And he said, well, what did he say? He was pretty calm up until this point. But anyway, he made the comment that something to do about the fact that we weren't able to extinguished anything with merging of titles, and he wanted to know why we would be interested in his hazard bond.
Might want to merge that and extinguish that too.
That's what I told him. I said we had the intention of merging the that debt title. That was a debt title. We were going to merge it. Well, we really hit a nerve because he really got irate and started yelling. And we were at a table with the 7 trustee moderating, and I was answering and discussing his topic, and he just got really loud, and so it was such that the moderator or the Chapter 7 trustee said, calm down, speak more quietly, and don't lose our tempers here. And so it was apparently a very touchy subject, and he brought it up. We didn't say anything about it, and he brought it up. So we assumed that we hit a nerve whenever we put the request in for his hazard bond.
Yeah, I think so. Yeah.
Boy, he was really irate with us today. And I told the Chapter 7 trustee, I said, I'm not mad at Mr. Kaufman. I think he's okay. I think that made him even madder. And so it's apparent that we must be touching some really sensitive nerves because he gets out of control whenever we start having dialogue between each other.
Sounds like kind of an irate man, huh? You can't talk to. So
the Chapter 7 trustee had a meeting with me about 2 weeks ago on Monday, and he told me, I don't know what you have done, but he says, I've been dealing with the Arkansas Department of Finance. He's been involved in these for 17 years, he said, in these bankruptcies. And he said, I have never, ever seen them so mad and so upset over one case as they are with this case with you. What in the hell have you done?
Well, you're knocking on the door to private equity, and they don't want that to be known.
Well, I told him, I said, well, I think I'm probably winning. So, I don't know. We've hired an attorney to go and help us do the Chapter 7 because it appears to me that they're trying to get us out of there. And the Chapter 7 trustee told me, he said it would be better if we hired an attorney and go and discuss our theories and then have that attorney to put those theories that we want to bring into the court into the language that the court can recognize. And he said we can get more done by having it done that way than we can if we tried to do it ourselves.
Yeah, but that might be at law, so it could be key part to get the attorney to not function as an attorney, but also as a private representative.
Well, I think I'm going to see if I can ask the attorneys to be a assistance of counsel rather than the attorney. I'm going to go ahead and allow them to represent the straw man in the Chapter 7 proceedings, but we still have the adversarial claim that's going on, and it appears to me that they're trying to get me to withdraw that.
Yeah, because that's your equitable claim.
Yeah. We were going to have a hearing on that last week, and the weather was such that the judge's assistant, or one of the attorneys that is the consultant for the judge, called me on my cell phone and asked me if I had considered continuing the case because of the bad weather. So I got with the other party, and we agreed that it would be better to put it off for another time. So right now we're kind of concentrating on Chapter 7 and not really doing much with the adversarial claim.
Hello? Hello? Did we lose you? Still on the board? Still there, Don? Hello?
Hello?
Hey, there we go. Try again.
Can you hear me now?
Yes, uh-huh.
Well, my attorney said that Mrs. Babin was one pissed-off lady. He said that she's used to being, now she's in the passenger in the past.
You're breaking up. You're breaking up, Don.
Can you hear me now?
Yeah, try again.
Can you hear me now? Hear me now? Hear me now?
Yeah, try again.
Okay.
Yeah, I've got a bad line here or something. You're like dropping out and breaking up.
Might alleviate that earlier. Donnie said he'd call you on the phone and get you on the phone line.
Okay.
Can you hear me okay?
Yeah, it seems like you're in and out, though.
Oh, well, if you hold on, we'll call you on the phone line. No, you have your phone? Well, maybe we won't be able to call you. Well, can you hear me well enough if I tell you, where was it that I dropped out?
You were just starting to explain what happened with the lady said.
Oh, he said that Joyce Babin was really pissed at me. She was really pissed off because he said that she normally is always in the driver's seat in these bankruptcy cases. And he said, here you come along, and now she's in the driver's seat. And I thought that was pretty interesting.
Mm-hmm. I wonder why.
A driver's seat. I mean, she's in the passenger seat with I guess one of those frames where you can't stick your hand through there and grab the steering wheel like you would be if you were in a police car.
Mm-hmm.
But I thought that was very interesting that he would tell me that she was now in the passenger seat. So apparently, they're talking to each other and they know what's going on.
Yeah, if we only knew more.
Well,
how long did this hearing last? How was it?
This hearing, we went to this. This was a meeting of the creditors this morning, and there was probably, I don't know, maybe 15 or 20 different individuals, or maybe even 30. They started out with a large group and put all them together, and there was like a dozen in that group. Then there was probably 10 more different groups, and I asked my attorney, "You suppose we'll be last today?" And he says, "You better bet. You can bet on it." And it certainly was. Everybody was cleared out except for us, and so whenever our case come up, we were the only ones in the room. And so I went up and started talking to the trustee, and then we covered all the usual things. And then Mr. Kaufman started asking the questions. The more he asked, the madder he got. And so one of his objections was that the bankruptcy trustee wanted to close out the case today, and Mr. Kaufman said, "Well, how are you going to pay off the payback plan that's being offered to you?" And I said, "Well, we'll just sell lots of tortillas." And he says, "Well, how are you going to sell tortillas? We're not going to give you a license." And I said, "We don't need a license." "Oh, I shouldn't have said that." He said, "Well, you're going to be selling them illegally." And I said, "No, we're just going to do it privately." And he says, "You can't do that." But he didn't expound on that. He just, and by then he was so red and he was huffing and puffing, he couldn't hardly talk. And this was after he got calmed down over the extinguishment of his hazard bond. I think he was really pissed about that.
Yeah, because if he doesn't have a bond, he doesn't work anymore.
I asked him for his bond and his certified copy of his law license.
He'll have to learn how to operate privately. Now he can't operate commercially then.
Well, not in the capacity of a lawyer. I think he was visibly shaken, and I think he fully understood what we meant. And I sent that letter to them as a shot across the bow, saying, wake up, guys. Not really meaning to go and do anybody any harm, but he asked me also. He said, "Are you going to sue?" And I said, and this is what I responded. I said, "I don't have to sue."
Sue for what? Sue for what respect?
Well, I'm assuming that he was asking if we were going to sue him and the Arkansas Department of Finance for damages as a result of their closing our business. They've closed everything under the color of law.
Right. Everything legal, yeah.
And it's all fraudulent, and they know it, and they know that we know it. And so he asked me today, he said, "Are you going to sue?" Of course, he didn't say, "Are you going to sue me?" or "Are you going to sue Arkansas Department of Finance?" or anything like that. He just said, "Are you going to sue?" And I said, "We don't have to." And that really ticked him off. Alarm.
Time to get up, huh?
But it was a very interesting morning. It's kind of interesting and also funny to see this guy who is I'm sure he's one of their top-notch lawyers for their. Of course, I'm not impressed with any of their lawyers that they have at the ADF&A, but this guy was visibly shaken. He was wrenching his hands and he was red-faced and squirming in his chair. He seemed like he couldn't get comfortable.
How much conversation you had with your attorney now?
I just hired my attorney yesterday because we needed to go in to do this today, and the Chapter 7 trustee was trying to accommodate us and get us out of get us set set up to where we could go back to operating our business.
Is he
And I hired the
bankruptcy?
attorney. Yes,
He's familiar with bankruptcy, right?
these are bankruptcy attorneys.
Uh-huh.
That's why he was telling me that that Miss Babin was visibly upset over me or pissed off at me because of the fact that they all know each other and they converse back and forth about what's going on. And I think we've become pretty well known in this case. When I hired the attorney, he said, "Yeah, I know all about this case." And so I listened to you guys in the hearings, and he says some of your stuff I agree with, some of it I disagree with, and some of it I don't even know about. Don't even know how it works.
Well, that's what I was wanting to dig into a little bit. How's this guy stand? What does he think? And what is it that he's capable of doing?
Well, I'm going to have a meeting with them probably in the next day or so, and I'm going to quiz them and find out how much they can do as far as my instructing them on what I want done and what they're capable of doing as far as...
They've got the license to operate on the legal side on the D.C. realm, and they can handle the bankruptcy from that point. But then he would have to switch hats himself and put on his private hat in order to help you out privately in equity. And that wouldn't involve his bar card license.
Well, that's what I'm going to try to ascertain from him as to whether he can go ahead and either do as I instruct and take this and do it, get it into equity so that the court can recognize it, or am I going to have to do it myself and have him as just
I would just blank right to the guy and tell him, are you aware that there are two sides to the court today? There is a private side, which is called equity, and there is a legal side, which is strictly legal, and the two don't mix. Oil and water.
I mentioned that to him yesterday, and
both sides.
I mentioned that to him yesterday about the fact that there's two courts and they run concurrently, and he said no, it's all at law and equity, and we discussed equity, and he says equity is a defense against statutes and codes, and that's what he was telling me. And I said, well, I don't think that's quite the way it works, but I didn't argue with him at that point because this was just a initial consultation. And I was just trying to get it set up so that we could do this today with the Chapter 7 trustee.
Mm-hmm. So it sounds like you're going to have an uphill battle with him, that he has got his certain opinions on how this is operating.
Yeah, and, I may either, one, have to educate him, or two, have to find somebody else. But they're charging me $3,000, so I'm expecting some help. And I'm going to tell them, if you guys screw me over and fuck me, I'm going to... Excuse my language. I'm not gonna sue you.
Yeah, because they might be able to handle the bankruptcy part, but they might not be able to handle the private part because, number one, they don't agree with it, and it's really a conflict against their own license, the bar card license. So.
Yeah, they might be between a rock and a hard spot whenever it comes to the equitable part.
True.
And I was in his office yesterday afternoon, and I heard him discussing that he had charged me $3,000 to take on this case, but he said the bankruptcy, they're going to be able to clean that up and get that all straightened out. He said, now he was talking to somebody on the phone. He said, but this adverse claim, I'm a little worried about. It may take a bunch more of our time to deal with that than we're charging for it. So he said they were taking a gamble on how much time it would take to adjudicate the adverse claim.
Mm-hmm.
But right now we're just kind of we just started working together on the Chapter 7.
Well, it sounds interesting. If you could get this guy in your pocket.
Well, I'm going to do everything I can to help him, and then if he's unwilling to do it, then I'm going to ask him to just be a standby counsel to assist me in doing it myself.
Mm-hmm. Yeah, because they're
a small law firm, like just two guys, and so one does behind the scene work and the other guy does the litigation.
Uh-huh.
So they kind of work as a team. We'll see.
What did you say first when you first started talking? There was something caught my eye, but I didn't speak up on it. You were starting to explain about what went on at the first hearing there.
You mean today or?
Today, yeah.
Oh, we just sat down and answered all of the questions that the trustee had. And, they go through all of their little spiel and everything, and Basically, it was all just a cookie cutter, follow the path.
You just started explaining that this was a creditors meeting, and you were saying that you sat down and talked with them, and the first thing that they said out of their mouth was what? I forget what they said.
I can't remember now. I have to think about it for a minute here.
Yeah, I think it was something about the legal.
Can you help me out a little more?
Well, I'm trying to remember what it was. Something about the legal, because it was the legal side that they were mad about, and...
Now, this is the Arkansas Department of Finance guy who was... he was asking me, he said, what is the legal authority to... something to do with his hazard bond. And he also asked me, well, what is a hazard bond? I don't know what a hazard bond is. All I know is that if you work as a lawyer working in the public, you have to have a hazard bond. And I said, you were an attorney, so you got to have one. He didn't say he didn't have or he did have. So then he asked me what the legal authority and what he was driving, or his point was that I didn't have the legal authority to merge titles and extinguish debt, so why would I want his hazard bond? I don't think I've come to the conclusion that he has not studied and done his homework, or he has no clue about what we're doing as far as merging of titles.
Yeah, from a legal standpoint, you don't, but from an equitable one, which encompasses the legal, you do. But just from your authority as legal, you can't. But as your authority from equitable, you can take over both realms. Because the equity side is the creator of the at-law side. It is the source of the at-law side. And that created thing, the at-law side, can't talk back to the creator.
Well, he mentioned that
where you're coming from, because if you're coming at them from an at-law side, then you don't have the authority. But if you're coming at them from the legal, the equitable side, you do.
Well, for someone who was telling me I didn't have the authority to do anything, he sure was visibly shaken. And he got very, very, very... He was yelling at me, and I was, I elevated my voice a little bit, and the trustee stepped in and said, hey, guys, cool it down here. You guys are really getting out of hand. And he was just out of control.
Well, I should have made a motion to the trustee.
All we were doing...
this man is way out of line, and he needs to be replaced with someone else that can speak more rationally.
Well, I don't really care whether they change him out or not. I don't have any animosity towards him, and I certainly don't feel ill will towards him. So I don't know what his problem is.
Well, you're a threat to their side. But
I told the chapter trustee sitting there, the chapter 7 trustee. I said, I don't have any ill will towards this lawyer. I'm not mad at him. There's no problem with me. I don't think he liked that very well, though. I was just kind of playing dumb, like, well, I don't know what the problem with this guy.
I think you're acing the adversarial claim.
The Chapter 7 trustee, he acted as if he didn't have a clue what we were talking about. And I know my lawyer didn't have a clue either, because I don't think he understands merging of titles. I've got to train him, unless he goes and does a little bit of homework. It was a very interesting interchange, especially to watch his body language.
So how about the adversarial claim now? What's the next steps coming for that?
Well, probably the next step will be to set a hearing date, and then I'm going to have the attorney to look at what we've got done and see what we might do to make adjustments to get that into equity and not keep it into at law. I haven't done any discovery yet, and this putting it off or continuing it to a later time, it's probably going to be 2 or 3 months before we get in to hear it.
Well, this adversarial hearing, the one you've been postponed, that was the one for the proving of the validity of the trust, wasn't it?
It is.
Uh-huh.
And the only thing that we were asking for was for a declaratory decree, whether the trust was valid or not. And this trust has all of the elements that the law recognizes as a trust, and so the judge will have to recognize it. And I think they know that. And it appears to me that we're getting a lot of subtle nudges from all of these players trying to discourage us from following through on this adversarial claim.
Yeah, because once you got it established that the court has recognized the trust, you've got the upper hand. Because now you can go for the breach of the trust And there's where you can put in your discovery and ask for the tracing of the funds and discover all the bonds in the background that's been attached, running off of it, drawing off from it. And you're opening up a can of worms that these people don't want on the plate.
Well, what does it mean whenever you have an individual who's sitting across the table from you and they're wrenching their hands?
Well, they obviously got something to hide. They're fear that they might get exposed.
That's kind of what I was thinking. This lawyer, and the last time that we talked to Miss Babin, which was on the 25th of January, she came over to me and she was wrenching her hands, rubbing her hands inside and out. As I spoke, and I noticed it was very, very obvious that she was doing this, and she appeared to be visibly shaken. And she said, don't you think maybe we ought to maybe dismiss this adversarial claim? Because this was at the point that the Chapter 7 trustee had given me a deal that I couldn't refuse.
You could probably feel the one he gave you. Well.
So, I don't know. She appeared to be, just like this lawyer today was, she appeared to be visibly worried. And whenever we went back up to see the judge, to announce that we were going to withdraw the motion to withdraw from the bankruptcy, the judge mentioned the fact that Miss Babin had been feeling ill. So I was thinking to myself as I was standing there, I wonder if she's having an ulcer.
or worse. High blood pressure.
High blood pressure. Well, it was kind of telling whenever the attorney told me yesterday that Mrs. Babin was really pissed at me because I come along and put her in the passenger seat. She was not in control anymore. So apparently that we've got something going that they can't dodge.
Yeah, but it's touch and go until you get the decree from the court that they recognize that there is a trust. Without that, you're powerless.
Yeah. Well, I think that it appears to me that they understand the possibilities there that we may be able to do that.
Yeah, so I would do it with everything within your power to make sure that you get the decree.
Well, it's fun to, this is starting to be fun.
Yeah, that's when you drive the stake in the ground, you claim the property, and the property is yours. Because the court is going to recognize, hey, you got an equitable claim. Well,
we're getting closer, but I thought we was really going to be able to get this at least determined whether we have a valid trust or not a couple of weeks ago. But the weather here has been, we've gotten a record snow for the last couple of snow periods or snow events that we've had, and so it's kind of thrown everything in a tipsy-turvy. But we're about ready to line it out, and have not yet received any word from the court as to when they would like to put that on the docket. So we're kind of just waiting now.
So it has to be rescheduled again, right?
Yeah, they got to reschedule it. I forget the wording that was in the request. It was at the convenience of the court or something to that effect. She's probably hoping they'll put it off for 10 more years.
Yeah, in the meantime, they'll run the 7 ahead.
Well, I'm thinking that, see, they're giving me a offer to buy back all of the assets for $25,000, and then the bankruptcy will be gone. Everything will be cleaned up. I'm thinking that that doesn't do anything with the background bonds, the bid bond, the performance bond, and the payment bond. All of that's still there, and so we still have a whole bunch of cleaning up to do, even if the bankruptcy is dealt with and done away with. And then we have the issue of the $25,000.
Yeah, tell them to take it out of the estate.
I have a trust with the Department of Finance. I have a trust with the major players and all the creditors. And so the trustee said, we need to see those and see what kind of assets they have in them. And so I'm going to tell the attorney, I'll give him copies, and I'm going to tell him that those are in confidence and he can't share those with anybody in the public. But he can. Can I share those with the attorney, or would that be breaching them? Because now he told me that we have a confidentiality agreement and that we can discuss trust.
True. Yeah.
So now he's looking for a statute trust which has got some sort of dollar amount value in.
Correct.
And this trustee, this Chapter 7 trustee, he wants to know what the value of that is. Oh, by the way, they asked a question. This is one of the questions they asked. They said, are you a beneficiary to any trust? And most of the people who said were up there said no. So when I went up there, I said, yeah, I'm a beneficiary to a trust.
What'd they ask after that?
He said, well, which one is it, or where is it? And I pulled out my birth certificate, and I said, well, that's the one, the set of KV trust that's represented by the birth certificate in the all-cap name. And he said, okay, and he gave me my birth certificate back. But everybody else who was asked that question said, no, they were not a member, or they were not a beneficiary to a trust. And I said, well, yes, I am. I have a trust.
Mm-hmm.
And he said, okay. Were all the people who answered that question in a negative? Were they not lying?
Were they not in what?
Were they not lying when they answered negative?
Well, in their own mind, they might not know. So does that make them lying? Although the truth would be that they are.
Well, would the people who are asking the question be perpetuating a fraud then?
Well, that could be also. It depends on which side your point of view comes from.
Well, now, whenever you get your Social Security card, does it not say on the back of it that it's a beneficiary card?
Yeah.
Is that not some kind of a trust?
Yeah.
So, in my opinion, then they have committed a falsehood by saying they're not a member of a trust. Well, I think if you don't have knowledge, then you can say that you don't know, and so if you say that, or if you don't know, then you can say no and be truthful about it. Yeah. But you don't have that knowledge. But the trustee's sitting right there looking at the beneficiary card.
Well, if you don't claim beneficiary, then you're obviously the trustee. They don't really say that. They're asking about the beneficiary, right?
Yes. Are you a beneficiary to a trust?
Yeah, so if you're not a beneficiary to a trust, they say no, then obviously they must be trustee to the trust. Because the only thing that's happening today is all about trust.
Well, I made sure that I told him, yes, I was a beneficiary.
Yeah. Well, you just made a claim for the equitable side where the trustee is on the legal side. So, and trustee's got legal liability, and he's responsible for the debts.
You think maybe the trustee may have to settle the debt?
The trustee does have to settle the debt, yeah. And since the trustee won't settle the debt, then that party has to come into bankruptcy, and then that trustee over top of it is going to settle the debt for them.
Well, so that might be his agent. Well, like I said, the attorney said they don't know what to expect whenever you show up. He said that was the reason we were last.
Want you out there with everybody else, which is part of the reason why they save you for last, because you have to do your private dealings in a private hearing. And that's so that everything is kept in confidence. They don't want everybody else around there to know, because it would be a breach of trust on their part, and they can't do that.
Yep.
So actually they're doing exactly what they're supposed to be doing, saving you to last. But now we know perfectly the right reason why they save you to last. So that,
well, I have a feeling that we're probably going to see a little different outcome on this Chapter 7 than we saw on the Chapter 13, because it seems to me it's going a little differently.
Well, I would have this attorney make sure that he stretches out the 7 so it doesn't get completed before the adversarial complaint gets heard, because what you want is the decree on the validity of the trust first. But I'm thinking that they're going to come at you first on the 7, get the 7 completed before you get the adversarial complaint. That way it gets you locked up in that, and then you can't operate because there's no need to do the adversarial complaint because they got you on the bankruptcy.
Yeah. So you think they might be trying to get him into a debtor-creditor relationship so that they can close it up and tie him up?
Yes. They're trying to close out the outlaw side first before you get a stand in the equity side.
That's kind of what I was suspecting. That's the reason they were trying to hurry up and get it shut down. Well, I threw a monkey wrench in the equation today, which kind of brought everything to a halt, and they had to extend it out. And that was
your drag line slowing everything down is the adversarial complaint. They know full well that if you get the decree on the validity of the trust, that they don't have a stand on anything at law.
Yeah. So
now you got authority established under equity, instead of being no authority under at law.
Well, I think we threw them a curveball today whenever we went in, and they asked me if I was a beneficiary to a trust. I said yes, so well, what about the house? I'm not trustee.
Well, make sure that they don't push you along on the at-law side and complete this 7 bankruptcy before you get the adversarial complaint hearing.
Okay. Well, you got the issue with the foreclosure. Yeah, I brought in the foreclosure, and the 7 trustee was, perked right up and said, "Oh, we got to go after that." So we have a foreclosure. Remember, we were talking about that we were in foreclosure and we were having issues with the court over that, and so we brought that into the bankruptcy today, and so it looks to me as if that's going to stretch it out a little bit.
Okay.
So maybe we can have the adversarial claim heard before they can get the foreclosure situation solved.
Right.
So that may buy us a little time.
Okay.
It appears to me that every time they think they've got us locked into something, we throw them a curveball and they have to start over again. They may be working with the ADF&A trying to get this done in the Chapter 7. Now, wouldn't I have to agree to it and sign off on it?
Yeah. That's probably what they're trying to get you to do.
Well, maybe this foreclosure issue will drag out for a couple, 3-4 months or even more, because it takes a while I'm thinking it takes a while to sell the real estate or whatever they've got to do. My attorney said that there was enough funds in assets or equity in that property that it would settle all the bankruptcy, and he said I'd probably have money left over that they would have to give back to me.
Mm-hmm. But that's all revolving around the legal side, not the equitable side.
Yeah. But we were trying to express the trust on that in the circuit court of the county, and they've been locking or closing the door every time we come to the door while they close it.
Can you incorporate that one into the bankruptcy too? That's.
Well, I think that's what they're going to do. They're going to bring it in. The attorneys. He told my attorney, to bring that in and liquidate it or something. So he was going to go back and lasso it with the rope and bring it in. So I'm thinking that's probably going to extend it probably at least 2 or maybe 3 months. Would it be advisable for me to write a letter to the court or to the judge and say, hey, I'd like to get a hearing to determine the trust and the adversarial claim and get that heard expeditiously, or would I just let them?
Yeah, you could put an emergency motion in there for the hearing.
Okay. Well, I'm wondering if I should involve the attorneys in that adversarial claim, or how would you handle that? Would you go ahead and try to them?
I would do it myself, yeah. I don't think the attorneys are going to be able to, and I don't think they know enough about it, nor would they be willing if they did.
Yeah. Well, that's something I will discuss with them probably tomorrow or the next day.
Their whole livelihood is derived from that law side, so they can't participate in equity as the card licensed attorney.
Well, could they, if they were to pull off their licensed hat and put on their private hat and say, okay?
Yeah, but it comes a conflict of interest to where, they're responsible for duties to the court, and which is at law, and then gets to be a conflict. So if you could find somebody that would, possibly. But, I mean, if my license was jeopardized, if my livelihood, to take a chance and come over here and play over here in this other realm, I don't know if I'd do that or not.
Well, I might be asking a bit much of them to do that, and
right.
My intention was to have them to do the Chapter 7 bankruptcy representing the straw man.
Now, maybe to advise you in the background, maybe on like the federal court procedures, maybe that would be doable. But to do it yourself, though.
Well, I think we've probably learned enough now that we can probably, with a little bit of help from them, we could do it ourselves.
Yeah.
Should we go ahead and do a dismissal order on the at-law side and put a bill in equity in for that case, a true bill?
I would put a stay on the at-law side and freeze the whole bankruptcy.
Put a stay in the adversarial claim to freeze the whole bankruptcy, or put a stay in the Chapter 7 bankruptcy until the...
No, the adversarial claim... Get the establishment of the trust, and then I would put in a stay freezing all the at-law side stuff.
Okay.
would be the bankruptcy in the 7th.
Well, it's becoming it seems that it's becoming clearer as the fog starts to evaporate that their intention is to try to get us through this Chapter 7 and get us out of bankruptcy, and then that'll save Miss Babin from her disgrace.
Yeah. But once you get the decree from the establishment of the trust, then there's a lot of things you can do from there. Use the at-law side, find out about where the equities are really, and going to lead to a whole different realm is going to open up.
Well, maybe the reason they're trying to get you out of bankruptcy. So.
Yeah, I think they're going to try to close you down in the 7 before you get the adversarial claim. That's what they intend to do. And I would be focused on the adversarial claim to put it through, get the decree, because that's going to establish the trust. And then you can go for the breach. You can establish a stay, and you can do the tracing of the funds, and you can establish the equitable assets, and there you can definitely do the extinguishment, and then you can extinguish the whole at-law side.
Which they're afraid of doing, I'm sure.
Yeah, that's what they don't want.
And extinguishment of hazard bonds and law license, stuff like that. They may not want us doing all that stuff. Not that we'd do that.
Okay, so work on your adversarial claim.
Okay.
Anything else?
That's about the gamut of it. Don't know that we have anything that we could pass on to anybody as far as what we're doing and how we're doing it. We're just kind of ad-libbing this as we go. So maybe whenever we get it all completed, we can write a book about it and pass it out to everybody.
Yeah.
What not to do. It'll be pretty thick.
Okay, well, we'll contribute wherever we can. Anything else? Or we're going with somebody else? Anything else?
We don't have anything else.
Okay, all right.
Have a good evening.
Okay, thanks, Don. Thanks, Doyle.
You're welcome. Thank you.
Okay, anybody got any questions? Press *6 followed by 1. *6 followed by 1. Anybody have a question? *6 followed by 1. 315, you're unmuted. 315, you're unmuted, New York. Hello, 315. They dropped off. Okay. *6 followed by 1. Anybody have a question? Okay. Now, New York, you're unmuted.
Christian.
Yeah.
Yes, this is Lawrence. I'm in upstate New York. I'm glad to get in to hear from you. Doyle, you're amazing, man. I'm up against the wall, and I'm listening to y'all, and y'all are just fabulous. Spreading the word, passing it just as you give it. Oh, you talking about setting a fire. Y'all keep on. We're listening out here. Y'all have a good evening. Thanks a lot to you, Christian and Doyle.
Okay.
Y'all have a good evening.
All right. Appreciate it. Darren, you're unmuted.
Yeah, Christian, just one small thing in regards to where we use, of course, our unalienable rights endowed by our Creator. Don't you think it would be better if we create our own technically speaking, our own Declaration of Independence as it pertains to our own specific circumstances?
Well, I don't know if we'd have a problem with it being recognized. That's why we use the Declaration of Independence, because that's so, foundational document that really nobody could really dispute it.
Right.
I mean, if we came up with a private document that says, hey, we've got unalienable rights, and it's like, oh, yeah, okay, now we've got to prove that one.
Okay. Yeah, even though, really, if you think about it, there is no federal or state agency that has the authority to claim your own status or who you are.
Nor do I think do. I think it's you to waive it. Or you waive it yourself, let's put it that way.
Well, you might waive a constitutional right. I don't think you can waive an unalienable right.
We're doing it all the time. Do you think that anybody out there today's got any kind of rights when the Declaration of Independence says that we do?
Oh, sure.
Well, we must have waived them all then.
Isn't that by voluntary consent?
Yeah, right.
I think there was also a Florida case that was like that, Pally. It was a divorce case, and I think in emphasizing the case, it says, I am who I say I am.
Yeah, with proof.
What's that?
With proof.
Oh, sure. The claimant.
Yeah.
Now, the same thing. If we want to claim the Sestacute Trust, then we should also set up our UCCs to also collaborate with that as well, correct? Where we would name
the SETI key trust or the birth certificate is a trust. It would be you'd have to claim that it's not a trust and be able to prove it's not a trust. Otherwise, it's just a plain birth certificate.
Okay, right. But basically, you would name the artificial entity, the all caps, as the trustee, would you not?
Basically, what you're doing is you're just doing a resurvey from a birth certificate into a trust. Same way that your mother formed it into a trust for you, a birth certificate for you, you're going to form it into a trust.
Right, but the debtor would be the all caps name, correct?
No, it would be the all caps name, but actually the all caps name is just a name for the trust. It's just a SETI key trust.
Yeah, but if you're setting up your callable titles under your UCC, you got to put a debtor's name in there.
Yeah, well, the name of the trust is your all caps name.
Right, that's right. That's what I was thinking. Same thing. Right, exactly.
That is the account. That is the res.
Okay, so if we were smart, we would set the all caps name, which is the substitute, and the birth certificate would be different as well, it would be the same debtor, which would be the all caps name, correct?
Well, really, the SETI key is really the beneficiary. The SETI key trust is really the account, which would be the all caps name. The SETI key is the real live man. And
okay, but I'm just looking at it because if you got to express it, you got to have the record, and on your UCC forms, of course, it does ask first line, who's the debtor.
Yeah.
So that would have to be the fiction.
Whoever the trustee is. The trustee on the account is the debtor. Who's the trustee?
That would be the fiction, though, correct?
Who's the trustee?
Well, it's not me.
Well, you are by repudiation, because we're all being repudiated to be trustees.
Yeah, no, I'm claiming grantor beneficiary on those.
Here's the actual trustee repudiating and sending you a bill, and when you don't refuse the repudiation, you become the trustee. And here all along, they were the trustee.
It's repudiation by default.
Yeah, by waiver.
But yet again, too, that default is not time barred.
Not on the equitable side. It is on the legal side, probably. They're always trying to limitations on the legal side to set up some kind of, statute frauds or statutes or something that puts a limitation so that you can't, forever come back in your time barred.
I'm gonna send you over that case if you want to look at it, because it does talk about in regards to being domiciled in a particular state where it's 6 months in the county and 1 year in the state, and if you don't claim it, your residency or citizenship is more or less declared for you. And once again, is what you're talking about, because you did not repudiate or you didn't claim anything else.
Yeah, no, that's at law. That's on the legal side.
Correct, right, but it's still a default.
On the
not on the equitable side.
Yeah, but not on the equitable side.
Correct. So I'm just, once again, because even the court,
even if you're down to what side can you play from, because what side you claim and what side your authority comes from. Either you're going to be on the equitable side claiming the equitable side and your authority comes from the equitable side and you have total power, or else you're going to be stuck by default by waiving it under the at-law side with the rest of the slaves, having no rights.
Right. But the thing is, because we want to make the records, and of course, like on the typical UCC forms, you have a debtor and a secured party, which of course you're going to change those designations. And I'm just saying, under the cestQ and the birth certificate, it would be the trustee or the debtor would have to be the fiction, because I don't want to be that. Those are the ones that always go to jail. I don't want to be the trustee. I always want to be the grantor and the beneficiary with all rights to take.
Yeah, but who is the trustee on that account? If that all caps name is the trust account, then who's the trustee on it?
Well, it would have to be the fiction, right? That's who they're claiming it to.
No.
Oh, but the trustee has to be a live person, you're saying.
Well, the trustee can be an agency, but then that agency still has to have a live party behind it, or an agent behind it. No, it's got to be who's the trustee. Well, we talked about this before.
Yeah. I think you did you say it was like Obama? No, someone said Obama. I think.
Obama.
Right.
Which Obama?
Well, it would be the commander-in-chief.
Yeah, that's the fiction. That's the agent.
Right, that's the agent.
Or the real trustee. And who's the trustee? He's the agent, as of the all caps, against and for the trustee. Who's the trustee?
Would it be
United States.
Yeah, United States. Right. He's an officer up.
So the United States is a fiction, so it has to have a real party. So the agent being the fiction, Obama's fiction name, but then there has to be, he's an agent, but that's a fiction also. So there has to be a live body behind that, which is the real man, Obama.
That would be the President of the United States of America.
Yeah.
Right, because he wears dual caps.
Dual hats. So he is the real live man behind the agent, who is the agent for acting as the trustee of the trustee being United States over the trust, the all caps trust account. Your name in caps.
Okay.
And you're the beneficiary on it.
Okay. So that's how we would have to set up. It would have to be, it would be him as the trustee or debtor on the UCC.
Yeah, the United States is the trustee debtor liable for all the debts of the beneficiary.
Right, but do you use an organization name on the UCC or not? Because you got to have a live person as a trustee.
Well, you put the agent's name on it.
Right, just the agent. You don't put the agency.
Well, he's acting in his capacity as an agent for the United States.
Okay. Right, so this way you can prove it. You can prove, hey, there is a trust here. Here's a trustee.
Well, if you got the intent, purpose, party, specific trust res and the method of formation, which is the trust test,
right.
And your documentation to back that up, yeah.
Right. Now, is that the same also on the birth certificate, or is that a different agency?
That's what we're talking about, the birth certificate, the set of key trust.
Oh, okay. Because my mind was going down to the other agents where, typically like on the fescue, because they put an identification number which goes under the Social Security Administration, and under the birth certificate it's under the Department of Commerce.
Well, we're talking about the master trust.
Right, and the master trustee, you might say.
Right.
Okay, fair enough.
Now, this United States trustee comes at you with some kind of agency claim through ABC Bank on a mortgage, and they send you the bill. Actually, they were supposed to send the bill to the trustee, United States, but they're looking to pin it on you, so they send the bill to you, and you don't refuse their repudiation, and then you become the trustee.
Now, also, too, with all our indentures, in any indenture we create, we have to send a copy also to the Internal Revenue Service, because they're the accountants.
They're the accountants, yeah.
So they get a copy of that, too.
Yeah.
Okay. I think we didn't really touch base on that much. Okay, that's fine. Only question I had, Christian. Just want to double check on a lot of stuff.
Oh, give notice to all parties in interest, and there may be more than just those parties also.
Okay. And of course, if we mess up on an indenture, we can always modify it, because the grantor is always allowed to modify it if we do make a mistake.
Yeah. Yep.
Okay, that's my only question, Christian.
350 or 345 under restatement of the second law and trust.
Okay, that's my only question I have. All right, thanks.
Okay, Eric, you're unmuted. Oh, it's not.
Hey, Christian.
Hey, Eric.
Hey, I was looking in that Henry Gibson's book for everybody's reference. I was hoping to talk to you about a couple things, just to see to put on those at-law eyes you have and those equity eyes to kind of talk about the how one compares against the other. And it's page 407 of the PDF, if you want to take a look at it. And it's going to be section 468, when and how exhibits must be proved.
Let me get there. So.
All right. And I was looking at this thinking this might be a great section to compare at law against equity, because of course we know discovery is an equitable part of the process. It's what actually invokes equity, as we've talked about before. But within everything, we know there's duality. So I was looking at this thinking we might be able to talk about the duality even within this equitable part of the at-law process, or if we're strictly on the private equity side, well, then we know it's strictly private equity over there, but still, I was thinking it might be a great opportunity to discuss it. And, of course, how Henry Gibson leans it towards, clearly towards the equitable side. But
What page is it on again?
407 of the PDF and 381 of the book.
381. Okay, got it. When and how must be proved?
Yeah, section 468.
Uh-huh.
Yeah, and as you see, it says exhibits comprise all writings, printings, and other things. Number 1, exhibited or annexed to a bill, answer, petition, affidavit, report, deposition, or other paper filed in a cause. Or 2, proved in a cause when not exhibited or annexed to any pleading or other paper. Now, I wanted to see, first of all, ask what they meant when they say proved in a cause when not exhibited. If it's not exhibited, how is it proved?
Well, like you get a decree for the proof of the validity of the trust, that becomes the evidence that the trust exists.
So that would be the proof, but it wouldn't need to be exhibited.
Yeah, that wasn't exhibited, although it was proved.
Okay.
Number 2, the cause when not exhibited. It'd be the order, the decree.
And of course, that's what we would all look for first on the NTT side, as far as tying it into everything we're teaching. But what about on the at-law side? Something that might be proved in a cause when not exhibited. The same thing as when there's an order in the court, right?
Yeah. The order has been ordered, so it's, I guess, it becomes a proof in the case.
And what else might be proved but not exhibited that you could think of in any kind of action or suit?
I don't know.
Okay. And then it goes on to say that number 1 under 468, exhibits to pleadings may be proved, and of course we know may means must, by affidavits filed with the exhibits in the clerk's office at any time before the hearing, or 2, by witnesses at the hearing.
Yeah, that's what they say. Everything it's said in open court becomes part of the record. It's already proven. Anything that's not said in court is said outside of court is hearsay.
But I was looking at number 2, by witnesses at the hearing. Well, that could certainly surprise the other side.
Surprises, not if you did it according to the rule. You gave them with enough time to prepare a defense. And the rules state that's, usually 10 days, about 10 days by mail, or say 48 hours by fax, or hand delivery, depending on what the rules are.
So, for example, if you were to depose somebody before a trial, for example, then you could avoid that issue of being surprised.
I don't quite follow you.
Well, I'm looking at this thinking, exhibits to pleadings may be proved, number 2, by witnesses at a hearing. So that means they would have had to file the exhibit ahead of time and proved by a witness at the hearing. Or they had to do it by an affidavit beforehand, just to make sure I understand the context here.
Well, you could get a witness
but they can't just,
and then put them on, and they give open testimony. That becomes the proof, because now you're cross-examination and cross-examination. Once it's done, then that stands.
But the exhibit still would have to be filed prior to the hearing, or they would have had to file an affidavit prior to the hearing, or
on doc, you have to list who you're going to have as a witness, because you just couldn't have somebody walking up in there as being a surprise witness.
Okay, but the exhibit would still have to be annexed to the bill ahead of time, so you could look at the exhibit before it was ever proven if they didn't put an affidavit there.
It doesn't have to be annexed to the bill. It needs to be sent to the other party with enough time so they can prepare a defense. Otherwise, surprise.
Otherwise, surprise. Okay, so reading on in this section.
That's basic government. You just can't surprise somebody with something.
And that goes right back to the premise of that discovery is the first equitable act that takes place in an action or a suit.
Yeah, you can't do that because that would be inequitable. You can't surprise somebody. That's not doing equity.
That's exactly why I wanted to talk about this section, because we really haven't talked about, whenever we're dealing with it, whether it be at law or some of the stuff that Doyle's doing on his side, as far as discovery and the first thing that we do being equitable, being discovery. We haven't talked about this in quite a while now, I know. So I was reading today and I saw this in here. I thought, what a great way to bring this back to all the stuff we talk about, to the very first place it begins. And then reading here, as far as taking it from the premise of equity, in the paragraph below where number 1 is, ordinarily no exhibit can be proved at the hearing by witnesses if it requires more evidence than the mere proof of its execution or of handwriting to substantiate it. And when they say of its execution, what do they mean by that?
How was it brought into existence? How was the document executed?
How did it take on some energy to mean something?
Yeah, when was it signed?
Okay. So the mere proof of its execution would be a witness saying, I signed the document, for example.
The document itself speaks for itself.
Okay.
If it's a notary, it's self-authenticating.
All right. And then it goes on to say, if the authenticity of the exhibit is questioned and a cross-examination becomes necessary, it cannot be proved viva voce at the hearing. Do you know what viva voce is?
Viva voice? Yeah.
No, it's V-O-C-E.
Voice. Speaking.
Oh, that's voice.
Her voice.
Okay.
Roll evidence.
It cannot be. So if cross-examination becomes necessary, it can't be proved by voice at a hearing. The examination of the witness is restricted at a hearing ordinarily to 3 or 4 very simple points, such as the custody and identity of an ancient document produced by its custodian. So when they're saying ancient document, what do you think that really means in that context?
Anything was formed in the past.
Okay. Could have been a minute ago or 10 years ago.
Yep.
Okay. And then 2, the accuracy of an office copy by the proper officer. That's pretty easy to understand. The execution of a deed or other writing by the attesting witness. And the handwriting of a letter, receipt, note, or other writing. The court may ask the witness questions suggested by adverse counsel. Now, that's pretty interesting that it says the court may ask questions suggested by adverse counsel. Isn't it usually the opposite side doing asking of the questions?
Court of its own accord can ask anything it wants.
All right.
The judge can do anything he wants on that. So that's under equitable.
What about equitable?
That's equitable.
All right.
That would be under equity. The judge at law, he's supposed to be a neutral party, and he ain't supposed to say anything. In other words, he can't stick up for your rights.
But a special master or magistrate or chancellor, that's a different story. He can't stick up for your rights, and actually has a duty to.
If something unequitable is happening in a court of equity, then he should speak up. Because the court has a conscience. Under at law, there is no conscience of the court. So that's why they don't have to act with a conscience in the court of law. Because there's no court conscience. It's only in equity does court have a conscience.
And in the outlaw side, there can't be a conscience because they're dealing with fictions. They can't see the real man.
Right, they're dead.
Yeah, they're dead.
They're all pieces of paper.
So it seems just that it would be inherent that a special magistrate would stick up for your rights, because how could he not with a conscience?
Well, that's why you're supposed to stay on the outlaw side. That's dead fiction land. You don't want to go in there, because as soon as you go in there, you're dead fiction. Dead fiction with no rights. And guess where we've been performing all our stuff? On the legal side all these times. Now we know why it never worked. You're on the wrong court. You're asking for the wrong things. You're breaching the trust.
So after this says here, the court may ask the witness questions suggested by adverse counsel, and a limited cross-examination be allowed. If, however, the court should see that the adverse party is surprised by the introduction of viva voce evidence, and that a cross-examination would not be sufficient to enable the adverse party to test the authenticity or genuineness of an exhibit, the hearing of the cause should be suspended, and proof allowed to be taken as to the authenticity or genuineness of such exhibit. So when they say proof allowed to be taken, what kind of proof would they be able to, would the party with the duty to produce the proof of the document, what kind of duty would they, or what kind of proof do you think they might be talking about here?
Well, any SOI to prove the claim.
And then they would have a certain amount of time to do that, and then if they didn't do it within a certain amount of time, they would lose their opportunity to prove their claim.
A certain amount of time to produce the record that substantiates your claim, your SOI, to back up your NOI claim. If you don't produce it, there is no record. You don't have a claim. He who claims anything must prove it. You'll not be making claims that you can't prove with SOIs, or else you ain't got no claims. Oh, I'm not that stinking fiction. This is a trust. Judge says, I don't see any fiction. I don't see any trust.
This is perfect to follow up with what you just said, because number 2 here says exhibits to depositions should be proved by the witness to whose deposition they are exhibited. So right there, just consistent with everything you're saying right there, right out of Gibbs' book. And then it goes on to say the depositions of subscribing witnesses to deeds or other writings should be taken with such instruments annexed thereto. So it looks like this says if you take a deposition, the instruments should be taken along with the deposition to prove the exhibits. Did you get that out of that?
Not necessarily, no. The only reason I want to use a deposition if I have fear that the actual witness is going to leave the jurisdiction, because I want the live witness. You use a deposition to put into posterity the testimony of the witness that you think is going to jump ship and disappear. Or you could use it for comparing one testimony to another testimony, and then using that as a ploy to impeach the credibility of the witness. Because he said one thing in the deposition that was taken earlier, and now in the cross-examination upon as a witness, then he purges his testimony on the first time. And now he's an incompetent witness. So you could use that as an offense or a defense. Offense for deposing a witness and proving he's incompetent, or as a defense to preserve a witness that may jump ship.
And then if, for those that have the book, below number 2, there's an affidavit to prove an exhibit. As far as a model, if everybody will refer to that to get an idea of what it is we're talking about and how Henry Gibson put it together. And then it goes on to say the master should attach the exhibit to the affidavit, mark it filed, giving the date, sign his name to the endorsement so that the exhibit may be fully identified. When a writing not exhibited to any pleading or to any paper in a cause is to be proved at the hearing by a witness, reasonable notice thereof should be given to the other party, but the chancellor has the discretion to allow an exhibit to be proved viva voce at the hearing. And looking at that discretion, that would obviously be something that would be in the conscience of the court, and that would, do you think that discretion would be exercised when there's someone's rights at stake of them not actually having the opportunity to exercise their rights properly?
We see how the foundation's set up in that affidavit? This is the first paragraph under Roman numeral 1, that he was present on the day the deed or writing now here shown him, marked A, and made an exhibit hereto, was executed by the parties thereto, and that he saw Richard Rowe, and give the name or the names of the signers of the exhibit, sign, or heard him acknowledge and say the deed or other writing, and that the affiant said his name thereto as a witness at the request of said Richard Rowe. Now this guy's got foundation set up to give competent testimony. Then it goes on, competent testimony, number 2, that he is well acquainted with the handwriting of Richard Rowe, the signer of the exhibit, and that the deed now there him shown, describe it, marked Exhibit A, and that it is an exhibit there too, was signed by Richard Rowe, and that the name there too is the proper handwriting of said Richard Rowe. And Affian also says that he is well acquainted with the handwriting of George Rowe, and that the name of George Rowe is subscribed to said deed and other exhibit, and is attesting the witness, and is the proper handwriting of said George Rowe. So the first paragraph was necessary to set up Roman numeral 1 to set up Roman numeral 2. Because if it came in and said Roman numeral 2, it was without foundation. No, Roman numeral 1.
Yeah, because right there, number 1 is that he was present on the day of the act took place. Now here shown, marked A, and made an exhibit here too. He saw Richard Rowe sign.
We
do the act.
Come in and we come in with number 2, and we just say, hey, that's his handwriting. No, you need number 1 in there first. We can't make out an affidavit right.
And that's consistent whether it be those of us that are learning here at ATT or a lot of the outlaw stuff you see, isn't it?
What's your authority to give this testimony? Just like the fella asked Dan and Doyle, or Don and Doyle. What is your authority on the legal side to ask for this bond? Like, what is your authority to foreclose in this mortgage foreclosure case, or this, you want to take my car? You know, what is your authority to take my car? Have they laid up proper foundation, like in number 1 there, to establish themselves with the authority to give valid testimony? What gives you the authority to speak as a competent fact witness? Or are you just saying out of thin air, okay, this is this guy's name. You validate it that way? That's an improper validation. That doesn't stand in court, although that's how they're beating everybody. They come in with the assignments and say, yep, we assigned this from ABC Bank lender to Wells Fargo who's doing the foreclosure.
And really, when you look at that affidavit to prove the exhibit, it's just so simple and logical.
We don't think simply, and we don't think logically. We're all slaves. We don't think at all. All I got to do is make a conclusory pleading. You broke my arm. I see no facts entered into evidence which says that this man broke your arm. In fact, I didn't even see that your arm's broke.
Yeah, just because you have a cast on doesn't mean it's broke.
Right. But we think, oh, these dirty, rotten judges, these dirty, rotten courts, these dirty, rotten people, they just ignored me. They rolled right over on me. No, I'm afraid it was all your stinking fool fault. Sorry.
And when you look at the way this affidavit's written, of course it's written from the frame of somebody who had to look at all these pleadings that people brought in there that were deficient. So he put in stuff that would make it ridiculously obvious and logical to where when he looked at it, he said, well, somebody was there to witness and sign. And then somebody was there to say that the person that they witness signed is they are well acquainted with that person, and that the deed now here shown, marked A, and made as exhibit here too, was signed by the guy.
Right.
You know, and after him probably seeing many cases where people were deficient back then as they are now, he said it would have been nice to know that the guy watching the guy sign would have told me he was there that day, and he spelled every bit of it out. That way I wouldn't have to guess and ask all these people all these extra questions when I could read in 2 seconds instead of going through 20 minutes of people yakking. I bet you that's where that evolved from when he wrote this book. He was sick of people talking and trying to figure out what they were saying to get something that he could have figured out in 5 seconds if he just would have had it in writing done properly. And of course, this is in the section of suggestions concerning proof. And then Article 5 underneath this section is practical suggestions concerning proof. So I knew that we'd have a good conversation about this evening when I brought this up. Just breaking it down, because every time we do break this stuff down in this book, I learn so much so fast.
The sovereign citizen wannabe needs to have this book as his equity Bible. All it is full of basic equity principles that government runs by.
Laid out sequentially and logically.
Yeah. And government law does not have to be hard. Law is easy.
And that's proven just by the way he wrote out this affidavit. The suggestion on how to prove an exhibit. It's really simple.
We're getting caught up on the statutes and codes, the 63 million statutes and codes that makes it feel like, oh, it's impossible. Well, yeah, on that side it is impossible because that's not law. You got common law, you got other law, whatever it is, but the source of that is equity. And I only need less than 20 maxims to come about and derive any law. And when I know those maxims, that's all I need to know, and I can operate without laws. I can operate in grace, and I don't need the laws. Now we're out of the kiddie pool, debtor-creditor sandbox that everybody plays in doing commerce. And if you're doing commerce, you're in the kiddie sandbox. And now I don't need to do commerce. I don't need to participate at law. That's where the sandbox is, at law. And I can operate in equity where the big people operate. So when I get to the age of majority, I finally grow up and I become one of the big people, and I find out I don't need to go in the at law. I don't need to participate in commerce. I can do equity, and that's the only thing I need. Now I can live by grace. And the world unfolds and becomes less confusing, and now I can see clearly because I put those spectacles of equity on, and now I understand where laws go right and wrong.
And I think Section 469 helps to further illustrate what you just said, because it says when you begin taking proof, if you have any witnesses whom testimony is vital, you should take his deposition at the earliest moment possible. And to follow up from what you just said...
Keep reading.
Huh?
Keep reading.
Yeah. If the witness is aged or infirm or going out of the county or state or is the only witness to a material fact, you may take his deposition at any time after filing your bill without waiting for an answer or plea. In no event allow any delay in taking your proof, especially if the burden of proof rests upon you. Many good causes are lost by negligence in preparing a cause for trial. And on the other hand, many doubtful causes are won by diligence and skill in taking testimony.
That's why we use discovery to win. Because without it, you're not going to win. You're going to come up with the evidence, the proof that the other side does not have what he needs to prove his authority as a right to take whatever he's coming to take.
And most of the time, people get served and they're scared and they run away, and they don't even know what was just in this paragraph that's so important. And of course, I was looking at this to take his deposition at the earliest moment possible. Well, a deposition can also be taken by interrogatories and admissions, correct?
Yes.
So as soon as you send that out and they start answering or failing to answer one way or another, you're getting some information that is vital to winning. So when I saw that, that really rung true for something I'm doing.
What's the maxim that equity aids the vigilant?
Yes, it is. That's perfectly in line with that. Earliest moment possible. Yes, sir. Yeah, we could probably find a bunch of maxims that apply to that very thing.
Try to comport our daily life into the 20 maxims. Do we? Okay, what is happening right now that I'm doing? How does equity apply to that, and what maxim applies? That's the only way you're going to get equity eyes. That is, if you practice on a moment-by-moment daily basis. Practice equity. And it becomes
second. It was interesting when you bring up about the maxims, and it says you should take his deposition at the earliest moment possible. And, of course, we know equity acts in personam. So let equity act on the person by taking the person's deposition to act on the person. Now, one of the things I wanted to know if these time frames are still consistent with what Gibson wrote in the book about keep in mind that all proof in chief must be taken within 4 months after issue joined, and all rebutting proof within 2 months thereafter. Is that still consistent today?
Where's he saying that now?
At below that paragraph I first read under 469, it's just before 470. The 2 lines there. Keep in mind that all proof.
Yeah, that's pretty much so, because the 4th month, that's the 4th 90 day. And they usually run on the 90-day cycle, so 30, 60, 90.
Wait a minute. I'm confused with what you just said. The 4th month would be the 90th day, or that would be...
That's after, and after the 90th day. Everything runs on 30, 60, 90. Well, the 4th month is the next month after the 90th day.
Okay.
It's taken within 4 months.
Okay, all right. And all rebutting within 2 months thereafter. So if you run... if the defendant puts discovery towards the plaintiff and they run discovery on it, because then you rebut with your discovery.
Yeah, if you got a certificate of dishonor from the notary and you don't do anything with it, usually it times out in 4 months. Why? Because it's equitable. There it goes. It says you're not doing anything with it.
Very interesting. Very interesting how all this ties together. And that what he talked about back in 1907 is still consistent today.
Yeah, 4 months is 120 days total. Well, that's, what is that, international law, 120 days.
So take note, everybody, that it's what we wondered whether or not was consistent back in 1907 is consistent today, whether or not a lot of the things in this book still applies.
Nothing's changed, even from back in Lewin's days. In 1259, nothing has changed. Nothing. It's still feudal times today with a different name on it. History repeats itself? Yeah, I'll say it does. It never left where it came from. It just got hidden by a different face mask, a different name. We just don't call it fee Hoffman anymore. We call it fee simple.
And 470, I think it really goes into some great stuff here about what must be proved. Have you looked at that yet?
No. Was it probably...
Well, the first paragraph in it really is probably it's so consistent to all this stuff that people ask for that they don't really need. It says a great deal of unnecessary proof is taken in almost every contested suit. This is generally the result of parties and solicitors not really knowing exactly what proof is requisite. The first question you are called on to determine after the plea has been replied to, or the answer filed is, number one, what are the matters really in issue?
Yeah, what is the primary thing? What is the root of the whole cause? What is the thing that everything hinges on? What is the pivot point, the balance point? Where does the root enter into the ground? Well, I don't care, whatever you want to call it, it's all the same thing. It comes down to, everything all boils down to one thing, and that's what you have to attack. And it's usually authority. What gives you the authority? What gives you the right? And do you have the proof to establish your authority?
So, for example, in a mortgage case, like that Massachusetts case where they got in talking about the assignments in blank, just like that, they didn't have the proof. And that's what they were really getting at that hearing that was in that video that we watched a little while back, is the real issue that everything hinged on.
Yeah, they weren't saying that we didn't owe somebody. We're just saying we just don't owe this fella because there's no proof that he has any contractual obligation with me.
And then it goes on to say in number one, to ascertain this, it is necessary to examine the bill and see what the essential affirmative allegations are and which of them have not been admitted by the answer. Nothing admitted by the answer is in issue, but every material affirmative allegation in the bill not admitted by the answer, and every material affirmative allegation by way of avoidance in the answer is at issue and must be proved by the party making the allegation. The question next in importance to be determined in preparing to take proof is, number two, on which side...
Now, let's back up a minute here. Let's just say... is an issue and must be proved by the party making the allegation. Now, does that seem today like what they're doing in the at-law side? Keep in mind what you're reading here is under equity.
Okay, answer me the question again, because I was just going back when you said back up a second.
Back up at number one there. It says it must be proven by the party making the allegations once you've taken and made the issue.
Right, the movement, the burden of proof's on the movement.
Yeah. Is that what's happening today?
And then your question was, is that what's happening in the at-law side today?
Yeah. Keep in mind that this book we're reading is under equity. And equity is not in the at-law side of the court today. You go into the at-law side today, and it says that must be proved by the party making the allegation. Is that what happens on the at-law side?
No.
No. Why not?
Assumption.
Because you're in the wrong court. You're in the wrong court.
Man, an attorney comes into court, they presume whatever he says to be true because he's an officer of the court.
Unless,
and officers, they never lie, right?
Unless you bring in the equity side.
But that's exactly why the presumptions stand, unless they're rebutted, because the attorneys are officers of the court. Anything else on that number one you want to talk about? Because number two is on which side rests the burden of proof, and we know what we're doing with NTT, and when we switch the onus probandi, the burden of proof, doing what we do. So I think this might be some great discussion. But do you want to finish up on anything on number one?
No, go ahead.
All right. Number two, on which side rests the burden of proof? Ordinarily, the burden of proof rests on the complainant. But whenever the defendant admits the material allegations of the bill and sets up new matters by way of avoidance, the burden of proving these new matters rests upon it. The general rule is...
Counterclaim.
All right, let me see where you see counterclaim in that. But whenever the defendant admits the material allegations of the bill and sets up new matters...
Bring in a counterclaim, you're now the party that has to prove up the burden.
And that's what they mean by saying sets up new matters, right?
Yeah.
Right. But they say by way of avoidance. But so a counterclaim would be a way of avoidance?
Well, affirmative defense is also.
Okay. Which is also a counterclaim. It's just not a separate bill.
Say affirmative defense on payment. You better have a record of a payment then. You got the burden of proving that you showed that that you've got a payment, that you made a payment.
All right.
Now, read the next sentence.
Well, just so you know, I saw that footnote number 4, and it says, as to the burden of proof, see section 441, 443, and 445. I don't know if I want to go there right now, but I just wanted to say, if anybody wants to learn about burden of proof, maybe we can look up those sections in a moment, though. The general rule is that whichever party makes a material affirmative allegation, on him rests the burden of proving it unless it is admitted by the opposite party.
Unless it is admitted by the opposite party. You better be good in discovery and getting admissions, because there's how you get the opposite party to admit. You got to know how to use the discovery tools. It's the only way you're going to win. The discovery is your scalpel to carve up the other side. Interrogatories and admissions sets up the admitted by the other party, and that's a way to set up issues.
Joe Pizza.
Yeah, because the issues that are set up are, you can get by operations of law, get them already established, admitted.
And when you send it to them, they have to respond, otherwise they're in default, right?
I can come in with a summary judgment, because there are no issues that are set up, or they're, say, and I can prove it with admissions.
So if they admit, then they're hung. If they come up with a good reason why they shouldn't admit, then they got to prove their good reason why they can't admit it. And if they fail to respond at all, then there's no issues, then you come in with summary judgment. Because when they admit on those admissions, they're making a claim. They better be able to back it up, NOI, SOI again, right?
Well, the opposite party is the one who admitted them by their own admission.
Mm-hmm. And you know, just thinking about what's equitable, and it makes perfect sense, because why wouldn't we go after the admissions to save the taxpayers' time for conducting a court trial when we can do this stuff all outside the court, get this stuff established, and not even worry about taking all that time to go through a trial? Just doesn't make good sense.
Answers to interrogatories are the basis to establish that there is no genuine issue as to any material fact.
And if there's no material facts, then there's no reason to have a trial.
Correct.
Uh-huh.
So if there be no genuine issue as to any material fact, the moving party is entitled to judgment as a matter of law.
So going back to the doctrine of NTT, that's why it's so important that we set up proper records to establish trust, because then there becomes an issue of material fact.
Well, you see, if you're operating with equitable principles at law, you will win at law, because your equity base is controlling the whole thing, both sides. And now you're no longer playing in the kiddie pool, just the at-law side, because you're using equity. And that's the only way you're going to win, is use equity.
And we can do complete justice that way.
Yeah.
You're not leaving half of it on the table. The most important half, obviously.
That's what arguing at law does. Leaves half of it on the table. You can't get an adequate remedy in half a justice system. They tell you that. But of course, you're just an infant in this, and you keep on coming in and playing at law in the kiddie pool. So, and the law keeps beating you up, telling you, wake up, wake up, wake up, wake up. You need equity. Wake up, you need equity. You keep playing over here in the at law side, keep getting beat up. Keep knocking your head against the wall.
As you said before, Christian, it's the dog going back to its vomit.
Yeah. Well, the statutes and codes beating you up as the tutor saying, hey, you know, trying to teach you the lesson that you've got to wake up, that there's another side here that's much bigger. Get out of the little kiddie pool. Reach the age of majority. Wake up. Make the choice for equity, not the at law. Can't win there.
Yeah, I want to go back to number 2, because there's something that I think totally applies to NTT here. Because it says the general rule, I'm going to go back a sentence, put it in context. The general rule is that whichever party makes a material affirmative allegation, on him rests the burden of proving it, unless it is admitted by the opposite party. The defendant must prove 1, payment, 2, a release, 3, failure or illegality of consideration, 4, fraud when set up to defeat the deed or contract alleged in the bill. Now that's a possibility with all these fraudulent suits that we see that these foreclosure mills are bringing. I see that one in number 4. Number 5, a former judgment. Well, then that's what we were talking about on the proof earlier. Okay, an order by the court. Number 6, a new contract set up in lieu of the one sued on, and that would be when we send the trustee the indenture, and then give them an opportunity to disclaim and send the res back.
Yep.
So right there, that's where the burden of proof sets up. That it's our burden to set up the records to say that there's been a new contract or indenture. Okay, agreement, contract. We could use the word agreement or indenture. We can substitute that word.
Yeah. Or
in lieu of the one sued on.
It could be 7 too, but.
Oh, I didn't get to 7 yet. Any other affirmative matter by him set up to defeat the cause of action alleged by the complainant. Yeah, it could be 6 and 7, obviously. So as we talked about on many occasions, number 6 is completely dependent on records and knowing how to get those records into the case properly.
Read the next sentence, next paragraph.
Defendants often lose when they have really good defenses because they are not aware that the burden of proof is on them.
Bingo. Dirty, rotten judges, the attorneys for them, they ran over me, they did this, they did that, and everything else, and you didn't know, you lost because the burden of proof was on you. We're all kids. All kids. and you don't even know it. I hear all these patriot guys out there complain about this, complain about that, the judges did this and all that. You know, you guys make me throw up. It's your fault. You don't know it. I was on a website one time, and I said the top 10 things that a pro se litigant must understand. And number one was, even when you know you're 100% sure of yourself that you're right, understand that you're wrong. And I thought, boy, frame that one.
And, of course, you know, Henry Gibson is going to give us some logical things to follow up on everything you just shared with us. You know that, right?
Judge asks everybody, hey, you're pro se. Do you understand what's going on here? Oh, yeah, we do, Your Honor. Yeah. Well, and then we claim that one that everybody says, what was that issue of Hallenbach versus whatever it was, or that one that says, you know, you're supposed to treat pro ses with less, I forget what that case is that everybody cites. You think they're going to give you any less slack than they give an attorney? No.
Well, you still got to know the rules.
That's our downfall. We don't know what the rules are. And not just the at-law side rules. You don't even know what equities.
Yeah, I think that's something really important to bring out. There are rules in equity, just like there's rules in everything. So Gibson went on to share with us some important rules of evidence. The following rules of evidence should be kept in mind in the preparation of proof. Number one, the best evidence possible must be produced. Logical, simple, but, you know, I'm sure a lot of people overlook that. Number two, the evidence must be pertinent to the pleadings. Number three, nothing is evidence at the hearing that is not on file in the cause. Number four, presumptions prevail until rebutted by other proof.
Now pay attention to number five.
Number five, facts known to the chancellor as an individual are not evidence. They got to be in the file, just like it says in number three. Number six, he who asserts a material fact in his pleading must prove it unless admitted.
He who makes the claim must prove the claim.
Number seven, he who confesses a material fact and avoids it must prove the matter in avoidance. And number eight, a preponderance of proof prevails. I knew this little section 468, 469, 470 would be great for some conversation. And we could talk about these sections quite a bit, I'm sure. But I just wanted to share those with everybody tonight to get everybody reading that section because it's so important of the things that are in there before we think we can ever go into court and think we're going to be pro se litigants. Again, Section 71 about waivers and 468, 469, 470, 471. For 471 is, and it says as to documentary evidence, 472 is when and what agreements to make in reference to proof. Henry Gibson will teach us all this good stuff, but we got to read it. So I'm surprised that more people aren't coming on the calls talking about this stuff that's in Gibson's book.
Because they're not reading it.
Well, hopefully we can encourage everybody to do
They
that.
understand what they're reading. Because they don't have enough foundational knowledge to where they can even understand what this guy's talking about. Why we don't have many calls, questions on the calls. It's not people are afraid to ask questions. They just don't have any questions. Why don't they have any questions? They don't have enough knowledge to formulate a question from.
Well, folks, this book is not that hard to read. Just come up on the calls and start talking, and we'll all learn something, just like we did tonight. I learned some things, that's for sure. I learned it today when I read it, and every time I read this book, I learn something. And sometimes I got to read these sections 5 or 10 times to really get the meaning, and then I talk to Christian, and then he gives me more meaning. So there's no reason that you guys shouldn't be doing the same thing. And if you still need more foundational knowledge, go to the past recordings. Go on Skype and talk to Faith to Trust and get the list of the 12 recordings or so that lay down so much great foundation as to what the doctrine of NTT is. So when you are reading this stuff,
yeah, because we're not stopping and slowing down for the newbies. We're going on ahead. We're forging on and we're completing this. We're going to the destination first, and then once we get to the destination, maybe we backtrack and we come back and help some of the stragglers.
Well, in any event, there's so much good information in the past recordings and in Henry Gibson's book. If there's something you want to know about, it's in those recordings and it's in this book to get you somewhere up to speed, at least to come on calls and have some discussion, because we'll all learn and we all want to learn. And thank you for the compliments, everybody, that you give us. But we want you to bring on stuff from this book and have some discussions so we can all learn.
We need a group of people who are up to speed that can handle the questions, or not the questions, can handle the topic. People can't handle the topic. But that comes with the learning, and that comes with time. So people got to spend the time. I keep on saying, there's no fine wine without the time, and everybody's got to put the time in, or else you don't become fine wine.
And we're looking to make a port here, by the way, everybody.
An Eric or a Marshall was not grown overnight.
And we're still growing. We have a long way to go. We know that much. Every time we talk to Christian, we know how far we got to go.
How long have you been on the calls, Eric? Since when?
Since October 30th, roughly, of 09. And I read almost every day. I'm reading some. I read these sections today, and I loved reading this stuff today. When I read that number 6, a new contract set up in lieu of the one sued on, I said, bingo! So I create my records. There it is. I got my proof that if the burden of proof rests on me, that I must prove that I have something instead that outweighs the complaint against me. If they come against me and I'm a defendant, well, I'm going to have some records to show that I have something that is going to show that there's something else here at issue. And that's what we've been talking about with the doctrine of NTT all along. But until you see it from a chancellor, laid out in a logical way, that you know that there's foundation behind everything we've been talking about for all this time, when you see that, that's when it really means a lot. That's when you know this stuff can work. Again, everybody, get Jurisdictionary by Dr. Graves. It's critical to your foundational learning. Critical. He's a great speaker. He puts it out there simply. He's been doing this a long time. He simplifies stuff for you. Learn what he's got to say. Listen to it about 100 times, and then read this book. Listen to those past 12 or 15 key recordings, and listen to every one of those recordings 100 times each, and then all the rest of the files out there that we've been talking about over the course of time, and you'll learn. When I first started into this, it was very difficult, but now at least I know how to ask good questions and bring up good stuff. But we're all getting forged by fire, that's for sure. Whether we decide to learn this or not, we're still going to face the fire. All it takes is that cop to hand you that ticket when you're sitting on the side of the road and saying, sign or you're going to jail. Well, if you don't know how to qualify your signature and you don't know how to know what your intent is when you grant that res, if you don't know what that is, then you just feel like you just got burnt by the fire right then. One way or another, though, that fire's going to come after you. Are you going to get forged by it, or are you going to are you going to turn into ash? That's the question. Well, Christian, that's all I really wanted to talk about tonight on the call. Thank you for giving me the opportunity to share that stuff.
Yeah, you're welcome.
If you have other people in the queue, please take them.
We don't have anybody in the queue.
Well, don't be shy, folks.
Everybody's been looking for a quick fix, and those people that are on, there really are no quick fixes. The quick fix is really the white gate that's luring you into thinking that that's all I got to do is, sign my name on some paperwork and not really understand it and throw it into the court or do something with it, and that's going to make my problem go away. You're deluding yourself.
Well, just in listening to the things that Doyle shared earlier, this is obviously not a quick fix for Doyle. It's been quite a learning process.
Yeah, but that's what everybody's looking for. They're looking for, like, the executive process, that all they got to do is put in somebody else's documentation, sign their name to it, throw it in the court, and expect that to work for them. Well, all right, I'll ask you. How'd that work out for you?
That judge was mean to me. He couldn't see that I had evidence.
I want to pick something that's easy so I can get back to flipping channel TV and taking Johnny to the soccer game.
We understand that Johnny has to go to the soccer game. We get that.
Yeah, but you got a mortgage foreclosure that's going to take you down next Thursday, and what are you doing in the meantime?
Right. Well, we all know there's plenty of stuff to distract us out there, but when it comes down to it, we got to figure out what's really important and what we're giving up by enjoying those creature comforts.
Yeah, I mean, this study doesn't last forever. Sooner or later, you're going to know up to a point. You're going to reach a plateau. All right, we got somebody that's in queue line, so.
Thanks so much, Christian.
All right, Eric. Thanks. New York, you're unmuted. New York, you're unmuted. 315. Hello, New York. Go ahead, New York. You're unmuted. Can't hear you.
Christian?
Yes, hello.
Thank you. I'm sorry, man. I'm sitting here talking to Denny. I talk on the telephone all day long at work, and cell phone is killing me. But anyway, I have a case coming up, and I'm listening in the background, and I'm understanding of the books and the directions, and everything is sounding right enough that I can verbalize rise from the hip, as you state, feels New York kind of thing. But the writing and understanding of it, I'm getting an understanding of the words and where to go. I'm getting the books. All praise Faith for her work. And all the old heads back there talking. Oh, and anyway, the understanding of knowing which, where, and starting from the first paragraph of the book. I can only talk it, but not in their language yet. And so there it is from the book. I got to get it. But as far as verbalizing, then I can make documentation. My records are going to start with the first one they just started this year off. It's time to start kicking them because I want to claim the marriage, everything, all of it's in relation as a trust. And once the documentation, that's in private.
Right.
Prepare subject matter, okay. Then we go in the back rooms. Then I bring out records. That's as quick and dry, and it's not, trust me, from what I've heard you say, it's not the end of it. But it's the idea that therein is you can see this rainbow of it. So I can get what you're saying, Christian, and Eric, appreciate it. Keep the phone in your mouth, Eric, you're doing great. Oh, you can read. And I'm just getting out of work in time to catch y'all and stay up late enough. I'm loving every minute of taking notes. I got notes everywhere. The girl is killing me. To ask you questions, Christian, sometimes it's better just to sit and listen with your mouth open, man, because, you're in deep waters, and sometimes it's better to just listen to adults talk. So I hang in the back, but I got notes. All of it's going to primarily be from the book and me doing it and presenting it by record. So thereby, understanding the examples that have already been brought by others and that this does work and it can be documented and proven. Oh, yeah. I wholeheartedly believe in it's like you can finally sit in the rabbit hole because you done got to the end of it because this is all of it. I want to see what Eden feels like. I really do.
Yeah, actually.
And this seems like this will get me there.
Actually, the debtor credit rabbit hole goes all over the place. But if
we're not going there at all.
Yeah.
I'm not going there at all. I wasn't even reading debtor credit. I'm talking equity.
Yeah, well, an equity hole doesn't go hardly anywhere.
It can't go anywhere. Yeah, it does go everywhere, correct?
Well, the goes everywhere under debtor creditor, but under equity, the rabbit hole goes nowhere. It ends right.
Well, I mean, as far as I'm getting across with what they're saying, because we are the beginning and end all of everything, and let me get it inside and bring it to you, and the other side can't say nothing. Okay, case closed, throw it out. Let's really and try and sit at the grown folks table about breathing atmosphere up there. Well, this sounds like a very good foundation, and I'm sure that I can.
That realm is
notice
he wants to spend the time.
Yeah, I am, but I do more listening because I stay on the go and at work. And anyway, so I hear you this way, and I'm just getting you on the phone. But
we have nothing exclusive that we're excluding everybody from this realm. No, it's. I invite everybody to study and come and join us, and you can join us if you study. But that's the key.
I am in the background.
Yeah.
I've got your audios. I've been reading transcripts, but I've got you all the way back to 2009. I've been listening faithfully, so that strongly just goes in and in and in. So when I get ready to put it on paper, after hearing it said and learning and reading it, it can be done. And so I'm building on it. Plus, there's others that are understanding that do see that there just might be something. So if they can see that it is going and somebody in their area has any other information to lead them towards you, I'm starting a group out here, upstate New York.
Great.
But it's all going to be about what you and the others are saying, because I'm just going to sit in the background. I'm not grown enough to talk yet. So, but this is all good, and I want to see, and I believe child support and any of the other agencies can be fought just as a debtor creditor, but also spanked with equity because everything comes from equity, and so it can't be done without equity. So who else is going to sign on the contract? So to me, that seems like the gist of it all and more. Don't get me wrong, not by a long shot, but so that the burden can be proven. Like I have the documents, I'm going to have you certified. If I notarized, is it still 3 days, or can you at least get 7 to 10 days?
72 hours is commercial, but you want to give somebody an opportunity to respond, so I would say minimally, commercially, 72 hours.
Okay. I was meaning for me to reply to their notice. But that's understandable. Okay, it goes both ways. No problem. I still got at least a day and a half. to go back over reading of the documents and things and notarizing and sending notices and noticing the parties involved and all the other stuff back together. Then I grab all my notes together and put them all together, and then I'll still get on Skype and ask somebody about it.
Well, sounds like another Marshall.
I can talk to them.
Sounds like another Marshall in the making.
Working on it because I do like his questions because he's like, let me write this down. I've been listening to y'all. I got y'all down pat. Y'all just don't know it. But anyway, you can tell by the jargon that I've heard a lot of it. And so that's a good foundation. I want to instill that in others, and I want to pass it on to anybody that I can and be a shining proof of it, too. So y'all just keep up. And I'm listening. A question, Christian, I couldn't even begin, but I have 1,000 of them. So I just have to read and write and find it.
Okay.
So I show the way. Little phrases. I write down 3 words. That's a whole half a book character read, but I'm getting there. Dynamite, man. Dynamite.
Okay, thanks. Appreciate it.
Anyway, say again?
I say I appreciate it. Thanks.
Well, I mean, if you was on that foot, because you always say ask questions, what would you ask yourself that you would be able to divulge fully, freely, that would be a guiding post? You'd mentioned read the books. And so therein, besides hearing and back y'all proving it by y'all's lessons, you're still pointing back like they do 200 years ago worth of stuff and working from there because we earned the right. Just got to prove it. Can we still send a letter to the lady in Washington to get a certified copy of the Declaration of Independence?
Yeah, I think it's still National Archives is the where you want to go. Send it to.
Yes. And see, there is some of the stuff you all mentioned in the back as foundational steps that have taken for documentation. I just wanted to catch up that the time spans are still good for them because there was a gentleman that passed a letter format for the lady, and I just wanted to know because I still had it for like 6 months, but still I'm working on getting there. So, and this presents itself. So sometimes you work best when your back's up against the wall.
Right.
And just listening because, like you say, what else would you ask yourself?
Would I ask myself?
Hypothetically, what would you be able to give to yourself in 25 words and be that wisdom right there?
Everyone's got to do it for themselves. Nobody can do it for them.
That's true. I understand that. All right. And I'm just listening because, like I said, I get more just listening than talking, so... Thank y'all. And if y'all got anybody else, I hope they take up another hour of your time. If not, y'all have a good evening.
Okay, thank you.
Thanks a lot, Christian and Eric.
All right. Night.
Good night.
Okay, I think we're going to call it a show for tonight, so we'll see you tomorrow night at 8 o'clock on the talk show, and we'll get into the exciting book by Lewin, The Practical Treatise on the Law of Trust. See you all then. Good night.